On the 7th of April of 2022, the Court of Appeal Criminal Division handed down judgment in the Crown and Michael Chang, which is reported at 2022 for Weeklies 49. The case concerned whether a police officer, being a servant of the Crown, was exempted from the statutory provisions criminalising the possession of offensive weapons, even when he was not acting in an official capacity. The facts were that on the 15th of April of 2020, Michael Chang, who was a plainclothes police officer with the Cambridgeshire Police, left Huntingdon Police Station at the end of his shift to drive home. He stopped off on the way in Kettering to pick up some shopping at a Tesco supermarket. In the boot of his car, completely in breach of the relevant police policy, he had a canister of incapacitant spray. That canister had been issued to him perfectly properly in the course of his duties, but when he went off duty, he should have left it in the locker allocated to him for that purpose. When he finished his shopping, he went to the Tesco petrol station to fill up, and it was there that he saw a row going on between a member of staff and another customer by the name of Davies. The officer, Michael Chang, thought, quite wrongly as it turned out, that Mr Davies was intending to make off without payment. He approached Mr Davies's vehicle, blocked his path, and started pointing at Mr Davies and shouting at him. When Mr Davies ignored him, Chang then went back to his own vehicle, opened the boot and took out the incapacitant spray. Mr Davies and his girlfriend both got out of their car, Davies to make a phone call and his girlfriend to start videoing the incident on her phone. And Chang then used the spray on Mr Davies, and some of it also blew into the girlfriend's face. In the meantime, Northamptonshire Police had been called, and one of their officers had seen Chang chasing Mr Davies and brandishing his baton before pacifying him with the spray. Unsurprisingly as well, the petrol forecourt was covered by CCTV, and the whole incident was caught on camera. Michael Chang was charged under Section 5, subsection 1b of the Firearms Act of 1968 with possession of a prohibited weapon. That section provides that a person commits an offence if, without authority, he has in his possession, or he purchases, or he acquires a weapon of a specified type, including any weapon of whatever description designed or adapted for the discharge of any noxious liquid, gas or other thing. Following a ruling by His Honour Judge Mayo in the Northampton Crown Court, Michael Chang changed his plea to one of guilty. He then appealed against his conviction with leave. Before the Court of Appeal Criminal Division, his counsel referred to Section 54, subsection 3a of the Firearms Act of 1968, which states that, for the purposes of this section, and of any rule of law whereby any provision of this Act does not bind the Crown, a person shall be deemed to be in the service of Her Majesty if he is a member of a police force. Counsel also referred to Section 54, subsection 1 of the Act, which states as follows: Sections 1, 2, 7 to 13 and 26a to 32 of this Act, so not Section 5, apply subject to the modifications in subsection 2 of this section, which contains modified arrangements for authorisation, to persons in the service of Her Majesty in their capacity as such, so far as those provisions relate to the purchase and acquisition, but not so far as they relate to the possession of firearms. The combined effect of those two subsections was, so suggested the appellant's counsel, that Section 54 subsection 3a extended the Crown exemption to members of a police force in all circumstances, and regardless of whether at the time in question they were acting in their capacity as police officers or in a private capacity. Subject only, counsel said, to the operation of Section 54 subsection 1, which had no application here since it didn't refer to the offence with which Chang was charged under Section 5 of the 1968 Act. In handing down the judgment of the Court of Appeal Criminal Division, the Lord Chief Justice Lord Burnett referred to Bank for Handel en Scheepvaart and Slapford, Town Investments Limited and Department of the Environment, Lord Advocate and Dumbarton, and Black and Justice Secretary. Lord Burnett then held as follows. Firstly, if the appellant's submissions were correct, not only would all servicemen and all ministers of the Crown be at liberty to carry arms at all times, including machine guns, pump-action shotguns, rocket launchers, mortars and missiles, but they could with impunity also do any of the other things with weapons which were criminalised by the 1968 Act, including manufacturing, converting or selling weapons, possessing firearms with intent to injure or other criminal intent, or to cause fear of violence or to resist arrest. The Crown Court judge had been unable to accept that submission, and so too was the Court of Appeal. Secondly, the acts of Crown servants that fell within the rule of statutory interpretation were those undertaken in their capacity as Crown servants, and there was no sensible rationale for extending the exemption to activities in their personal lives. Thirdly, whilst it was right to say that section 54 subsection 3a did extend the category of persons who were considered Crown servants for the purposes of the exemption, the section did not modify the rule of statutory interpretation itself. It was clear that the rule of statutory interpretation only extended to Crown servants acting in their capacity as Crown servants. Therefore, it could only exempt a police officer from the offence-creating provision contained in section 5 of the Act if the police officer was acting officially as such at the relevant time. Fourthly, the effect of section 54 subsection 1 was to apply certain of the provisions of the Firearms Act of 1968, albeit in a modified way, to persons in the service of Her Majesty and acting in that capacity, where they would otherwise be exempted from those particular provisions. But the fact that it didn't apply to section 5, insofar as those persons were concerned, had no relevance here, since section 5 already applied to this defendant in the circumstances of this case. At the relevant time, he had not been acting in the capacity of a police officer, so he couldn't pray and aid the general Crown exemption. And so, for all those reasons, the defendant had been properly convicted on his guilty plea, and the appeal against conviction was dismissed.